Thank you. Please be seated. We are now here for our final argument of the afternoon, State versus Amble and Mandracchia. Sorry about that. You guys know how to pronounce it? Okay, Mandracchia. I'll go with you. Okay. Thank you. And we will start today with Mr. Wessan.
May it please the court, counsel. This court in Wright established a new framework for searches and seizures to determine whether they violated Article 1, Section 8 of the Iowa Constitution. The legislature promptly responded by enacting, with large bipartisan majorities, Iowa Code 808-16, which intended to fit within Wright's framework. The district court here applied Wright and found that the statute was preempted and thus void by the determinations made in Wright itself. That was error. Instead, this court should apply the test in Wright, which asks 3 sequential questions about whether a search is constitutional, or in the alternative, if it determines that the law is not compatible with Wright itself, it should revisit Wright. But to turn to Wright, the 3 sequential questions, as we see it, are first, is there a search? Second, is that a search of a person's home, effects, or papers? And then third, if there is a search of a person's home, effect, or papers, is that search unreasonable? Here, all parties agree there was a search. So the question is, the question to ask is, 1, is a person's effects being searched? And 2, if it is that search unreasonable? The legislature here attempted to answer both of those questions, not by intruding upon the judiciary's prerogative to make constitutional findings, but instead to answer some of the questions that were raised at Wright itself, set certain baselines in the positive law while respecting the protections of Article 1, Section 8, and balancing the vital interests both of Article 1, Section 8's protections with the needs of the police to protect the community. For example, the definition of when a effect becomes abandoned. As this court recognized in Wright itself in Part 4C and reaffirmed later in Burns, abandoned trash cannot be the basis for an illegal search under Article 1, Section 8. So here, the legislature explained that the intentional act of taking the trash, putting it in a receptacle, and then putting that on the curb is enough to demonstrate abandonment, such that a later search of that trash by an authorized law enforcement officer, as shown in 808-16-4, does not intrude upon a person's effects.
Sorry. All right. I'm older. If we agree with you that the statute is constitutional, and by putting garbage out for collection on garbage day, it is abandoned, you don't have any, constitutional rights in it anymore. Can we stop there without addressing whether other provisions of the new statute may have gone too far?
Unlike when I'm normally up here defending against a facial injunction against a law, this is a facial injunction of a different sort. It came up in a suppression hearing. And the district court's order found that the evidence here must be suppressed because the law, 808-16, was facially invalid under Wright. If this court agrees with the state that the law and Wright are complementary and there is no conflict, and that the trash in the bin is abandoned, it does not need to address any of the other parts of the law, because at that point, there is not a search of a person's effects. This court doesn't need to reach the third question at all. And as to some of the follow-up questions that this court in Burns and 6 justices have said in Baller, dealing with the unreasonable nature of the search, don't come into play. Burns put this best, and Burns said, when trash is abandoned, there is no interest in that trash that is protected by Article 1, Section 8. This is also complementary to one case that issued after the briefs were submitted here in City of Orange, which also dealt with a facial challenge under Article 1, Section 8. There, the court found that so long as there are some valid applications of the law, that facial treatment was improper.
how far could we extend this? So let's say that the legislature passed a law that says whenever someone leaves their car for more than 4 hours, it is considered abandoned and police may search it. Is that valid? Would that be within the bounds of what the legislature could do?
Your Honor, and first, I would suggest that for many of the hypotheticals that could come at issue here, there are other constitutional protections outside of Article 1, Section 8. For example, the Takings Clause that might protect property in certain circumstances. But to address the hypothetical head-on, the legislature enacts a law saying if you leave your car for 4 hours, then it is abandoned. The difference between that and the trash is that there is an intent here to get rid of the trash. And that is evidenced by the fact that you must take the trash out of your house, put it in a bin, roll it to the curb. Up until that point, the trash is not abandoned. There is a strong intentional act under the law that shows that evidence of abandonment, and that's consistent with how the legislature has treated abandonment both in some personal and even in real property other contexts. The legislature largely defines abandonment law to the extent that there is not some preceding precedent. And that conforms perfectly with Wright's invitation in Part 3E, I believe, at footnote 5, to say that the positive law, and again, we don't need to get to the positive law analysis because we're not getting to the search, but the entire framework of Wright, as the state sees it, is it sets forth rules through which the legislature, or in some circumstances, cities or counties can enact municipal codes, and each of that contributes to the positive law that then informs the later searches. So here with the car, unless there's some real strong evidence that you're trying to abandon it, that really defeats the purpose.
Kind of thinking through, so then the legislature gets to say, we will find as a general proposition that people intend to relinquish rights to property in this situation, and if they find it, we have to abide by it.
From our brief is at Iowa Code 556G, dealing with dry cleaners. If you leave your dry cleaning at the dry cleaners for more than 4 months, it's abandoned, and the reason it's abandoned is because the legislature said so. This is a very similar application of the principle that the legislature may enact laws dealing with personal property so long as it doesn't run afoul of other constitutional principles, either under the U.S. or the Iowa Constitution. Here, there is no U.S. constitutional issue, as this court has recognized. Greenwood is still good law.
With you on the legislature's ability to define property. Also that it would probably be political suicide to take people's cars after 4 hours and it wouldn't happen. But what about special access type of laws? So instead of a finding that a car was abandoned, let's just say that there was a statute that said, police officers shall have the ability to pop the trunk of a car whenever they feel like it. Would that be permissible?
Your Honor, that would likely not be permissible, and the reason for that is that the car remains a person's effects. Then we can move on to step 3, which asks about an unreasonable search. One other alternative grounds, which is not quite the question you asked, but is one that I think is important for the state to address, is that in Burns itself, there was a partial rejection of the Bowden-Stern article's explanation that it can never be the case that law enforcement may have special access by statute. 729.63 C2, if I recall correctly, was a statute that gave a special carve-out to police to search for genetic data. This is exactly what 808.16.4 did here. And the reason for that is straightforward, because there is a strong law enforcement interest in these types of trash pulls. As this court acknowledged in Wright, most jurisdictions to address this question have followed the U.S. Supreme Court precedent and allowed it to go forward. But what I see here is actually a salutary example of the conversation between coordinate branches of government. Here, the court spoke. It created a new framework for searches and seizures, and the legislature, acting responsibly in the next legislative session, passed a law to try to fix some of the problems that were identified in Wright to ensure that police can still access trash when needed in their law enforcement duties, while at the same time not unduly intruding or unconstitutionally intruding upon the rights of Iowans. And that's an important policy balance that, as Bowden Stern, as Wright itself acknowledged, the legislature and the positive law are not quite one, and this court recognized that there are limits on what the legislature can enact. But when looking to what the positive law is, I believe Burns said the legislature is the best evidence of what the positive law is. And that makes sense because the positive law includes statutes, rules, regulations, this court's decisions, all of that goes in, and ultimately this court is the adjudicator of what is and is not constitutional, but the legislature plays an important role in setting those terms.
Turning to subsection 1 of the statute, and I understand your point that this could be resolved just on the definition of what constitutes abandoned property. But the definition of expectation of privacy, or just the assertion that the public doesn't have an expectation of privacy, is that a similar kind of fact or legislative power that the legislature just has the authority to declare? It seems different in kind than subsection 3 about abandoned property.
Reasonable expectation of privacy test, which many members of this court have criticized, but is part of the right analysis at step 3. I see 3 different components of that step 3 analysis: the positive law, the trespass approach, and the reasonable expectation of privacy. Reasonable expectation of privacy includes both the subjective and objective component. Looking to Burns, what Burns said was that when the legislature acted to say that police could search for genetic data, that eliminated a reasonable expectation of privacy in the straw. Here, Part 4 says police are allowed to search this abandoned trash. So I don't see any circumstance where this court will ever have to reach the constitutionality of 808-16-1, because 808-16-4 under Burns does enough to authorize the police to show that there's no objective reasonable expectation of privacy. So to a certain extent, if this court is troubled by 808-16-1, there's no need for an injunction because it's more of a statement of purpose or policy. This is clear that all 4 parts of the law were intended to address the concerns that this court raised in certain warrantless searches.
Point that the section 3 kind of is the predicate that allows the assertion of subsection 1 that there's no expectation. Let's assume you have a different kind of statute that deals with like data privacy, for example. Could the legislature just say people have no expectation of privacy in their email without other changes that would change the actual kind of legal right to privacy?
Question directly in one moment, but first I would say that there probably is no reasonable expectation of privacy in email. The third-party doctrine still exists in this state, and to the extent that police or law enforcement want to get access to information held on a third-party server, there is longstanding precedent under both federal and Iowa constitutional law that likely would allow that without any legislative change. But to address whether there could be a law saying you have no reasonable expectation of privacy in a certain subset of property, whether that be digital or physical, the best approach is the approach that this court has already used in Wright, in Baller, and Burns. The legislature is an important component of positive law. It is not the sole component of positive law. And to the extent that there is an unreasonable search because of analogy to some sort of tort, trespass, unlawful act that has a strong basis in the history of this state, that would also weigh. The legislature doesn't have a trump card, so to speak, but it does play an important role in the conversation. And here, when we're dealing with garbage, dealing with trash, I think it was the plurality opinion in Baller recognized that dog sniffs only go back to 1888. I tried to look to find when municipal trash collection began in Des Moines. I couldn't find the date, but generally speaking, it was the 1880s to 1890s. It's a similar historical background.
Before you run out of time, can you address what it means by publicly accessible area that is throughout each of these provisions? That allows, does that mean that they can go onto someone's curtilage to get the garbage?
Yes, Your Honor. And that's consistent with, for example, the Des Moines Municipal Code that authorizes a right-of-way for trash collection.
Des Moines Municipal Code, if they didn't have that code, does that change things?
No, Your Honor. So far as I'm aware, every single trash receptacle or municipal trash collection service in the state of Iowa is done through city-owned bins. The idea that, and those bins must be placed on the curb for the collection. If those bins are, for example, in a garage, the police can't enter the garage to access that trash under this law or under Wright more generally.
could the legislature then enact a statute that said that people do not have an expectation of privacy in illegal contraband because it's illegal? And so therefore, they could bring, say, a drug dog onto their curtilage or onto their front porch to sniff it.
Unfortunately, not familiar with Iowa case law as far as dogs on a curtilage. I know that dogs in a home go too far, obviously. That's a tough question, especially because the dog question itself is often referred to as sui generis in a lot of contexts, but a law purporting to allow warrantless entry into a home because there is a reasonable suspicion of drugs in that home would be unconstitutional, and the legislature could not change that fact.
But you're not willing to say the same thing about if it, without a warrant, sniffing on there or searching the curtilage?
Your Honor, that's a pretty difficult question for a lot of reasons, but fortunately here, if I may continue, Your Honor. Fortunately here, we're dealing with the motion to suppress on facial invalidation. If there are later questions that arise that raise some of the thornier questions in the edge cases, that would be the appropriate case to deal with that. Here we have a situation where the curtilage is not implicated. We're dealing with trash pull in a consistent with the statute, consistent with right fashion, and it was suppressed because there was a misunderstanding that right and the law themselves conflicted. So if there are no further questions. I think there are. Yes.
What about other types of garbage? Garbage left in the hotel room. I think there was a case involving that. I live in an apartment building. We have a private pickup. If there's garbage done by a private company, those are not covered by the statute. Those are not deemed abandoned property.
Your Honor, as the first question, the answer is yes, they are not covered by the statute. As to whether they are abandoned property or not, I hesitate to say whether trash left in a hotel room or in a public area in a building are per se not abandoned. Looking at the specific facts that might arise in a case, I could see that going either way, but I certainly agree that this law does not change the legal status of trash in those circumstances.
Could you address under stare decisis, should right be overruled, our precedent on precedent?
The state is working hard after right to find workable solutions, and this law is part of the workable solution that the state is trying to do to balance both the protections of Article 1, Section 8, as well as the needs of law enforcement. To the extent that this legislative fix is not possible, and the court deems that consistent with what my friends on the other side are arguing and what the district court said, that really there is no legislative fix that is possible, then right itself is a 4-year-old opinion. There has been a lot of disruption. Right now there is a patchwork of policies across the state dealing with the propriety of trash rips, given both the current status of the statute, which has the suppression motion here, but is being enforced in other places, and right. This court can take notice of all of that, and it would not be, we're not quite aged out of this is a longstanding precedent. It's still being worked with, but hopefully this court agrees with the state that the legislature's attempt to pass a law that would allow police to do their job safely and and respecting the protections of the Iowa Constitution are reflected by their actions, and thus overruling right, at least right now, is not appropriate in this case.
Mr. Irwin, are you going next, or is Mr. Kragnes? Okay, Mr. Irwin.
Thank you, Your Honor. May it please the court. The judicial branch and ultimately this court has the sole responsibility and power to interpret the Iowa Constitution. Section 808.16 is a blatant attempt by the legislature to wield that power, and thus it is in violation of the separation of powers. I'll come right on and say I think the first sentence of subsection 2 is maybe valid. Everything else is not, including the designation of garbage as abandoned as a per se rule. But throughout the statute, I mean, I don't think it could be more, Your Honor, Because that's a legal fact-specific question that simply can't be, for constitutional purposes, cannot be announced by legislative fiat. I am aware that there are laws which discuss abandonment. The laws, for instance, the dry cleaning law is supported by the fact that a person leaving their clothing there for 4 months is strong evidence of intent to relinquish all right, title, and interest. But other
Of a really beautiful blouse that's missing. I never intended to, I'm serious, I never ever intended to do that. But if I'd have put that blouse in a canister out in the hallway or in the alley on trash day, how can those even be compared to each other?
property, Your Honor. So I'll take a moment. I think when the legislature has used that term abandonment, it's something different than this. So for instance, there are laws that say a car is abandoned if XYZ circumstance exists. If I take that car, I have no doubt I would be prosecuted for theft when the owner showed up. It's not the same thing as constitutional property abandonment.
The trash collector who comes through Polk City, do they need to come up and get my consent each time to take?
Contract with them to do that specifically. And for that purpose, I think a couple of distinctions. One, which I would like to make that was never really discussed in right. None of these cases really talk about the garbage can. Whether leased from the city or one's own private property, that is not going anywhere. I don't know how you abandon property by putting it inside of other property, which is going to remain on your own real estate. So that's one major flaw in this entire analysis. They all skip the garbage can. Your Honor, garbage reveals a great deal about personal life. I know it's easy to dismiss in that way, and if we're just talking about banana peels, fine. But there are immense amounts of information to be found in people's garbage. There is mail. There's just a huge amount of information that can be obtained through garbage, which is being intentionally concealed by placing it in opaque garbage bags, by placing those bags in an opaque garbage can. I just think there is it's just not abandonment under those circumstances. And so throughout this statute, they refer to expectations of privacy, papers, and effects, the warrant requirement. There's no way that by statute, the legislature can just say police never need a search warrant.
Well, I think here, as I continue to stare at Article 1, Section 8, the right of the people to be secure in their persons, houses, papers, and effects. It's really their effects are kind of the key words to me. And why shouldn't we look to the legislature's determination of what is yours, what is theirs? If they say that it's not yours anymore, then it's not your effect. Why can't they take it?
Cannot make that declaration as a constitutional matter of law because there's a specific test which exists that is a fact-bound, case-by-case basis test for abandonment, particularly for purposes of giving up your constitutional.
You keep saying that, but I'm not sure.
Sure, Mike, nobody can hear you on the recording end. Yeah, that's why. Maybe it needs to be tightened or something. Sorry, we're not picking you up at all. Thank you.
Body of law that talks about the legislature having the authority to define, create, eliminate property defined and property interests, and those are subject to constitutional limitation. But unless you could point to something that would say the legislature has no authority in this arena to define when garbage is abandoned or not abandoned, when it's yours, when it's not yours, I guess I would ask you to point to something more specific that would prohibit the legislature from deeming garbage abandoned, other than the assertion that they just can't do it.
Section 1, Your Honor, it's separation of powers. This is an assertion of constitutional dimension. That is this court's purview. That is not the legislature's purview. And it's also problematic because it's an assertion of fact which is not true on the ground. And for that reason, the abandoned portion is very similar to the back and forth about the assault statute. The legislature cannot just announce an assertion of legal significance that is not true as a matter of law and have that be binding on the people on this court. There are certain limitations on the legislature's power, I don't think it necessarily matters that this court had already spoken, but particularly when this court had already spoken and said, yes, garbage bags and their contents are paper and effects, for the legislature to simply say, no, they're not, violates separation of powers, because that is this court's purview exclusively.
Right is overruled, correct?
I, of course, would urge this court not to overrule Wright. The state even today has given no compelling reason why it should be, other than that it agrees with the dissents in that case. And I know it was a plurality decision, clearly hotly contested, but the fact is the majority held what the majority held. And the state's complaint that, no, we think the dissents were correct, is just simply not enough to overcome stare decisis, even in the Constitution.
That all the legislature has to do is pass a statute, and then you can get around Wright. Is that really a precedent that's worth preserving?
Right means, Your Honor. That's never been what right means. That's what footnote 5 made expressly clear. And it's also what I want to touch some on the, Your Honor.
It's only the plurality, not the majority, right? Correct, in Wright?
I believe it was in a section that Justice Apple joined, but I would have to double check the opinion for that. Okay. But in any event, that's the problem, and the Bowden Stern article talks about this, that if you are going to take this approach of positive law dictates the scope of constitutional rights, it falls apart if the legislature can carve out exceptions. That's why the exclusively trespass approach frankly doesn't work and was never
I mean, it seems to me that the thrust of it was to have legislative bodies make determinations about the appropriate scope and authority of law enforcement powers. And in that case, we had said we thought it was inappropriate because there was a body of ordinances that dictated the police act one way. And now the legislature has said, no, in this state, this is how we think that the police should act, and it grants them that authority. I think we all agree there's some sort of limit somewhere. I'm not sure if garbage on the curbside is the outer bounds of that authority, but it seems to me this is kind of consistent with what Wright said, which is that ultimately legislatures should have responsibility about governing police conduct. Why is that wrong?
Cannot give police power that lets them violate the Constitution. The Constitution of Iowa is the floor for rights of Iowans. The legislature can't pass a law that says, for instance, police can search these things without a search warrant and have it be effective if...
I mean, they have changed. No, they have changed historically over time the authority of police to act that were different than what happened at the common law. So take, for example, the powers of arrest. The powers of officers to make arrests has grown over time, and they used to have to be able to witness a crime, and then they could make an arrest, and then that was expanded. Now they can arrest on reports of misdemeanors. I mean, they've always expanded police powers. There are certain limits. So I guess I'm just not buying this argument that the legislature has absolutely no say about what police can do, and that the legality of police conduct is solely a judicial determination in every circumstance.
They have absolutely no say, and I may have overspoken. I also don't mean to say they cannot pass a law. I think that was Amicus's point. My response is the legislature can pass all the unconstitutional laws at once. They just can't take effect. And in the instances you're giving, it sounds to me like the legislature had given greater protection than the Constitution requires and then said, you know what, we're going to take that away. The legislature can do that, but the legislature can't move the floor below what the Constitution requires, and that's what they did here.
Is in McDonald's portion of the opinion.
Joined by Justice Apple, that's what makes the majority. No, I apologize.
It's in the plurality.
Fair enough.
Part 3, I'm looking at it, part 3.
If we agree some parts of the statute are unconstitutional, can't we still reverse by relying on a part that is and sever the bad parts?
Constitutional, which would uphold this search, but it isn't. As I said, my view is only sentence 1 of section 2 passes muster. That sentence frankly says you can only adopt ordinances for public health and cleanliness. I've never seen a trash ordinance that says for protection of your privacy, no one can go in the garbage. That's what the ordinances do already. So yes, the legislature can change, and the positive.
We disagree and decide the part that defines what is abandoned. In this case, we say that is constitutional. Do we need to address whether the remaining parts of the statute go too far? Or can we just leave that up for another day?
Yes, because that is this court's purview. When the legislature has blatantly violated separation of powers, this court should speak up. In its supervisory role, if nothing else, yes, the legislature should be rebuked for any part of this which is blatantly unconstitutional. I want to give my friend Mr. Kragnes some time to speak, but I would ask that the district court's order be upheld. Thank you.
Good afternoon, may it please the court, counsel. Please allow me to introduce myself. I'm Chris Kragnes on behalf of the appellee and defendant Charles Amble. With the court's permission, obviously I'm open to any questions that the court may have, but I'll start my focus on stare decisis and related to this matter. First and foremost, as we've already discussed, this is a young decision. This decision is now only 4 years old. I believe it was 3 years old at the time that the briefing and whatnot took place. This court has stated numerous times in the past the reasons in which a decision should be overturned. And those reasons are a highest possible showing that the precedent should be overruled is clearly erroneous, that there has to be a compelling reason for that, and also that it has to be proven to be unworkable in practice and undermine some form of subsequent factual or legal developments. The practical reality is, in this circumstance, the citizens of the state of Iowa deserve some consistency, continuity, and this court should not look to right as a change. The precedent was established. That precedent should be maintained.
Stare decisis that right itself overruled longstanding precedent and ran counter to well-settled federal precedent and the law in nearly every other state.
And Your Honor, the issue when you look at right in that context, first, it was decided only under the Iowa Constitution. Obviously, the federal precedent would matter. It was taken into consideration. But that's also part of what we're looking at in terms of stare decisis and the precedential value of something. We understand through the lens of time, things can change. Most certainly, this court can look at things differently on a current end compared to a distance past. We have numerous examples of longstanding tradition that frankly were overturned by this court, matters that we can't believe probably were valid law at a point in time in the past. That's not where we're at here. Where we're at here is we need a circumstance in which we respect those decisions that this court has made, and that every time we have just a little change or we don't like it. Yeah.
Say right is great and it's workable and it's fine, and yet the state's saying we can reverse the ruling on the motion to suppress, use the evidence against your clients, and still leave right alone. And I assume you don't agree with that meaning of right.
Wholeheartedly agree that I don't agree with that meaning of right.
Yes, that maybe right is a little bit hard to follow, unworkable.
Your Honor. What that suggests is this court made a determination. I see my time's going to be ending. May I continue? Thank you. This court made a determination in right as to what personal effects were, how that they were protected for the citizens of Iowa, and what the government, the state of Iowa, could do. The fact that the state doesn't like that and utilizing some of the language that has already been utilized by others, they can pass any law that they so desire. Whether it's truly valid and enforceable is the question. We can all make things unworkable. The state can try to make right unworkable. Right is clearly workable. The effect of that decision is we as individuals, and using perhaps just identity theft as an example, we throw away things in the privacy of our trash. We have a mechanism in which we get rid of that trash, but that doesn't necessarily mean we're losing our privacy interest and our protection in that. And that's what Wright was saying, Your Honor. So I don't believe it's a circumstance where we have something that is clearly unworkable. With that, I would have nothing else as the time has expired unless the court has any additional questions. Thank you.
Thank you, Your Honor. Wright set forth a 3 sequential question test to determine whether searches are constitutional. The clash here can be resolved on that second question regarding abandonment. A lot of the substance of Wright, the hard work of Wright, is actually part of question 3, which this court need not reach so long as it addresses the abandonment question at part 2. But perhaps most importantly, there are several aspects of the argument made by the other side that I'd like to address. This court's decisions do matter. They have an effect. Wright itself had a real serious effect, which is why the legislature enacted a law taking into account Wright's framework. Wright itself at footnote 5, I see that as a good for the state footnote because it invites positive law. Looking forward a little bit to the plurality decision in Baller, it explicitly referenced 808.16 as an effect of changing positive law, which would fit into Wright's third question. But this court, because it seems there might be more disagreement as to the substantive after effects of how to deal with the positive law, the trespass issue, perhaps the reasonable expectations of privacy, can leave those questions for another day because the facial invalidation of 808.16 effectuated in the motion to suppress itself rested on faulty premises.
Can you provide some guidance on the question that Justice McDermott asked about the car being abandoned and opposing counsel's argument that the state just can't redefine property in this way or can't deem it abandoned? And I suggest there is some limit, but can you help kind of illuminate what those limits might be in terms of how far the state could go in deeming property abandoned or just defining something as, not being property at all?
Yes, Your Honor. Going back to this court's precedent, requiring the explicit intent to abandon the property is a key component in the test. That is why what 808.16 did works, because when you make the affirmative decision to place your trash in the bin on the curb for collection, you are in the same way that you sign a contract with the trash collector for your house and you understand that someone is going to come and take that trash away. What this law does is say there is no preemptive effect on that municipal ordinance or that agreement between the homeowner and the trash collection agency that precludes law enforcement from, if they have reason to search that abandoned trash as well, search it. But that doesn't preempt, for example, to the extent that there are other municipal ordinances that might stop other people, scavenger ordinances, for example. And I could understand under an earlier conception of Wright without the clarification of Burns, how that could have caused a problem. But because Burns itself recognized that there can be carve-outs for police conduct so long as it's consistent with the Iowa Constitution, that it did not fully adopt the Bowden-Stern approach that said such a carve-out is inappropriate or unwelcome, that here Burns answers that question. There is a carve-out in Part 4 that says police can access this trash to search it, and it's abandoned property at the earlier question. To the extent this court wants to go into some of the follow-up or historical questions, we don't think that's necessary. There have been...
Overrule Hahn, because that case, there was no ordinance there, no positive law basis. So what do we do with Hahn?
Was that it said that there was an appeal pending when Wright came out, and it remanded to apply Wright in the first instance. Hahn did not discuss an ordinance But the positive law itself is not limited to ordinances. The Baller plurality did focus on the ordinances. Those are very helpful to determine what the scope of the privacy interest is. But looking at the law here, those ordinances, to the extent that there's a conflict, are preempted. That's the one part of the law that my friends on the other side seem to think is effective. And then beyond the preemption effect of the state, which I don't think anyone is questioning, the definition of abandonment, going back to what Justice McDermott and Justice McDonald were asking, Iowa Code 556 defines all sorts of personal property and when it's deemed abandoned. This is consistent with a longstanding policy of this state.
With me, I mean, you're using different language, but I think I said in my plurality and Baller that I thought Burns was taking maybe a different take than Wright took, and you're saying Burns clarified Wright. Is that? I mean, either way, Burns involved a statute, and we allowed that statute to define what the or we recognize the effect of that statute. Let me put it that way.
The most helpful case to me in trying to figure out this court's Article 1, Section 8 jurisprudence is both the plurality and the concurrence decisions in Baller, which looked at Wright from different perspectives. The three sequential test comes from the three justice concurrence aspect of that case that goes through exactly what happened, and the plurality defining how it perceived Wright and its effect was also incredibly helpful. What Burns did was it took Wright, which addressed a whole bunch of different issues, and applied it to the situation at hand, very similar to here. There's a police carve-out, there's abandoned trash, there's a specific legislative enactment that says police are allowed to search the abandoned trash, and we're just asking that between Wright and the 6 justices that agreed in Baller and Burns to continue along the same path towards finding a way for workability while at the same time respecting the extremely important rights guaranteed by Article 1, Section 8 of the Iowa Constitution. If there are no further questions, Your Honor, the state respectfully asks this court to reverse the motion to
Follow up on stare decisis. We often look at reliance interests in deciding to adhere to precedent. Are there any valid reliance interests that would justify keeping Wright on the books?
perspective, Wright, as not modified by the statute, was in effect from when it issued in June until the legislature tried to complement that decision in the next legislative term. In the scope of the state history going back to the 1857 Constitution, that's not a very long time at all. One other aspect I maybe just want to flag that I didn't touch on, the idea that there is a Article 1, Section 8 protected interest in trash, municipal trash, such that it can never be modified, and that this court's decision in Wright, which, if I recall correctly from the Wright discussion, there was a lot of questions about when the trash becomes abandoned. And the legislature heard that discussion and said, here's where we're drawing that line. And that line seemed to be at a reasonable place. It was a place that was discussed by the justices. But it seems odd to say that now there is a constitutionally protected right in garbage that can never be amended by the legislature. I know that I'm far over time, and I respectfully ask this court to reverse the decision below. Thank you.
Amble and Mandracchia is hereby submitted, and court is adjourned for the day.